odd, and now it is 30 odd. I don't know why. It's exactly 30. I don't know why that's happened. But all right, nevertheless, let's make the most of what we have. Let's start today with our second session. And to begin this session, we shall start off by looking at the legal framework in India for M&A in detail. So let's quickly start up with the Companies Act of 2013. So the Companies Act of 2013, as you all may be aware, provides the statutory foundation for all corporate restructuring transactions in India, which include mergers, amalgamations, demergers, and arrangements. So the principal legal authority under this act, as you know, is the NCLT, that is the National Company Law Tribunal, and this supervises and sanctions M&A transactions which involve both public and private companies. Now, the relevant provisions for you in this regard would be sections 230 to 240 ideally, which lay down the procedural and substantive requirements for implementing schemes of compromise, arrangement, and reconstruction. So the process typically begins with the formulation of a scheme of arrangement or amalgamation, which must be approved by the respective board of directors of the companies that are involved. Now, this is usually followed by an application to the NCLT, if you recall from last class, for calling meetings of shareholders and creditors for approval by requisite majorities, which in this case is usually three-fourths in value and a simple majority in number. And thereafter, the NCLT may sanction the scheme if it finds it uh, fair, reasonable, and not prejudicial to the interests of stakeholders. We also have a system in India that we discussed in last class called fast track mergers. Uh, right, before I get on into section 233, does anyone from last class recall what fast track mergers are? Anyone from last class, do you recall what fast track mergers are?
So I have not seen the whole recording of the class, but as far as I can remember of my memory, I think the fast track mergers are basically where you don't have to take the permissions from the desired channels or something. Basically, you fall under the specified regulations. Like if like just a hypothetical scenario, if you fall under net profit of 5 crores, so you can go through directly to the deal without taking in permission or notification from the desired channels. Is that the fast track merger?
Yeah, you're partly correct. I mean, you as conceptually you're completely correct, but some of the details are missing. It's just that. Thanks, Yash. So just to clarify, the fast track mergers provide a streamlined process for mergers between, small and medium companies, and because of the lower turnover or lower profit generated, they are allowed to bypass an approval by the NCLT. And I mean, apart from that, these will also involve companies like startups. And usually the process will involve sending notices to the registrar of companies and official liquidator, which will ultimately seek shareholder and creditor approvals and filing of a declaration of solvency. So let me just come back to get addressing it to you in detail. I hope that's clear to everyone, though, that fundamental meaning of fast track merger that I just gave you. Okay, if there's any doubt, please unmute and ask. Uh, Coming back to what I was saying, so Section 233 of the Companies Act, as I had mentioned, it has introduced this uh, revolutionary concept in corporate law of fast track mergers, which will, as mentioned, is a simplified process available for small companies and mergers between a holding company and its wholly owned subsidiary. So, unlike regular mergers, as I think Yash mentioned, these do not require, he said, administrative approvals, I believe. So, I would slightly clarify that it is NCLT approval, as I had mentioned, while like correcting Yash's answer for everyone's convenience. And it can be concluded with confirmations from the respective regional registrars and official liquidators, which I just mentioned. So this is especially beneficial for uh, startups and intra-group reorganizations where the need for judicial oversight is minimal. We also have Section 234 of the Act that permits cross-border mergers, which allows Indian company to merge with foreign companies in a jurisdiction that is notified by the central government, or vice versa. So such mergers require approval from, as we discussed in the last class, Reserve Bank of India and must adhere to FEMA regulations, which we'll be discussing in detail. So cross-border mergers may be inbound or outbound, as we had discussed last class. Again, does anyone recall what inbound and outbound mergers are? The name suggests it. Come on, inbound, outbound.
So done within India and done without out of the limits of India. Is that
Again,
inbound?
partly correct, partly correct.
So sorry.
No worries. So inbound merger is when a foreign company merges into an Indian company. That's why it's called an inbound merger. And outbound merger refers to an Indian company merging with a foreign company. So that's why it's called outbound. So each poses unique regulatory, tax, and compliance challenges. So the Companies Act also mandates that the scheme of merger must be accompanied by a valuation report prepared by a registered valuer to ensure transparency and fairness. Now, in addition, the views of regulatory authorities, such as that we discussed in our last class also, which we'll be discussing in detail today, the Income Tax Department, the RBI, SEBI, and the Competition Commission of India may be solicited during the NCLT proceedings. Now, the tribunal must be satisfied that the scheme is not prejudicial to public interest, as I had mentioned, and adequately protects the rights of minority shareholders and dissenting stakeholders who are permitted to raise objections during the hearing process. I mean, it kind of becomes a task if you look at it practically, because there are shareholders who will definitely oppose because of their economical interests that are vested, and they might have their own reasons to oppose it. And at the same time, even though, I mean, obviously, the dissenting stakeholders also ideally would only include the minority shareholders. Now, if a merger still does happen, while they are deriving economic benefit, there's always a risk of operation mismanagement that can be created in the process. So, to avert that, you obviously have operation and mismanagement redressal mechanisms under the Companies Act. And at the same time, you also have reasonably clear and beneficial exit strategies and exit provisions for shareholders from the company itself, should things go out of hand, of course. And some shareholders merely may want to exit because they're not satisfied with the merger. And consider this, that even when there's a group of minority shareholders, if they are making sense to the NCLT, that's always going to play a key role in NCLT deciding whether to give the merger a go ahead or not. So if there are like things as pressing as conflict of interest, or you know uh, I mean, interests not being satiated over the process, or them disagreeing, or some improper modality or functionality or process not being followed by the board of directors and getting a resolution approved before going to the NCLT. So all of these things will definitely be factors that the NCLT will consider, provided they are served with adequate proof for the same basis, of course, preponderance of probabilities and not beyond reasonable doubt, because it's a civil, I mean, it's a civil dispute by the majority shareholders. Let's then come to the second bit of things in under the legal regime, which is the SEBI regulations. So M&A transactions involving public listed companies attract additional layers of regulation due to the need to protect retail investors and ensure market integrity. So SEBI, as the capital markets regulator, has issued comprehensive regulations that govern the acquisition of shares, change of control, restructuring, and delisting of listed companies. Now, the most critical among these for M&A is, as we discussed last class, the SEBI SAST regulations, or the SEBI Takeover Code, That is the SEBI Substantial Acquisition of Shares and Takeovers Regulations of 2011. So, just to take you through the thresholds again, under the takeover code, any person or entity acquiring 25% or more of the voting rights in a listed company is mandated to make an open offer to the remaining shareholders to acquire at least an additional 26% of the company's voting shares. Now, this requirement is designed to give minority shareholders an exit opportunity when there is a need or when there is a change in control. So additionally, even if the 25% threshold is not breached, an open offer is required if an acquirer gains control. And what do we understand by control? It is it uh, it will include the right to appoint a majority of directors or control over policy decisions. So the regulations also permit what we call creeping acquisitions, uh, uh, whereby an acquirer uh, holding between 25% and 75% of the voting rights can acquire up to 5% additional voting rights in a financial year without triggering an open offer. You also have what we call indirect acquisitions, which is like the global acquisition of a parent company that holds a controlling interest in an Indian listed entity. And they will also ultimately attract open offer obligations if the transaction results in a change in control of the Indian target. So, in such cases, SEBI will evaluate whether the Indian shareholders are indirectly affected and whether an open offer must be made. This was important for the takeover quota. Before I come to go to LODR, does anyone have any questions? It might be a little convoluted, which is why I'm asking if anyone has any questions. If you want me to repeat anything, please let me know. Yes, yes.
So, according to the takeover code, you just said that acquiring 25% of the voting shares requires an obligation for the other persons to ask that either you can take 26% more of voting shares, right?
No, 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 no. I think that's been mistaken. What I was telling you is if there is a person or an entity that is acquiring 25% or more of the voting rights in a listed company, uh, or more of the voting rights in a listed company, they are that is mandated to make an open offer to the remaining shareholders to acquire at least an additional 20% or 26% of the company's voting shares.
All right, sir. Got it. And so one more thing.
Yeah.
All this is required under the share purchase agreement, or an asset purchase agreement would require the same obligations.
This is a takeover code. No, this is acquisition, share, substantial acquisition of shares and takeovers. So this is
Okay.
only applicable to purchase of shares. So it will only come via SPA, not an APA, like a share
All
purchase
right.
agreement.
All right, sir.
Yeah. Any other questions? Okay, I take that as none. Let's move on. So SEBI's LODR regulations come next, which is basically our SEBI's listing obligations and disclosure requirements regulations of 2015. So these impose continuous disclosure obligations on listed companies. Any proposal involving mergers, amalgamations, or acquisitions must be promptly disclosed to the stock exchanges, and depending on the nature of the transaction, it may require approval from shareholders through a special resolution. So these disclosures are essential to ensure that all investors have access to price sensitive information simultaneously, thereby maintaining a level playing field. So, in addition to this, if you recall from last class, we had one more regulation which is important uh, for situations where transactions where a delisting of shares occurs from the stock exchange. So that is when you have the SEBI delisting of equity shares regulations 2021 that become applicable. And these regulations stipulate that delisting must be carried out through a reverse book building process, which will basically ensure that shareholders receive a fair exit price determined through market forces. So SEBI also regulates the issuance of securities during mergers through the SEBI ICDR regulations of 2018, which is the issue of capital and disclosure requirements of the regulations of 2018, which govern preferential allotments, share swaps, and other means of raising capital in the context of corporate restructuring. Any questions, anyone, before we move on into the Competition Act of 2002? Can see Yash is the only one who's been active in today's class. Last class we had more people who were active. I don't know why everyone's gone a little silent today. Yeah, Malaika.
So, how is merger any different from combination?
Again, for this we'll have to go back to the first class. I will give you this in detail when we connect.
All right.
Any other questions? All right. Let's come to the Competition Act of 2002 then. So the Competition Act of 2002, which is enforced by the Competition Commission of India, uh, introduces mandatory merger control regime for combinations, like obviously will be which will include mergers, acquisitions, or amalgamations, which meet certain thresholds relating to the value of assets or the turnover. So you have sections 5 and 6 of the Competition Act of 2002, which I had mentioned. Which I had mentioned in last class as well, which lay down the jurisdictional thresholds if cross require parties to notify the CCI and obtain its approval before consummating the transaction. So these thresholds apply both the individual party at the individual party level and the group level in India and globally. So what is the process like? So the parties to a combination, like which will basically include a merger, acquisition, or an amalgamation, must file a notice with the CCI using Form 1, which is called a short form, or Form 2, which is called a detailed form, depending on the complexity of the transaction. So once notified, the CCI conducts a phase 1 review to determine whether the transaction is likely to cause an appreciable adverse effect on competition in India or not. So if the commission has concerns, it may initiate a phase 2 investigation involving a deeper scrutiny, market data collection, and potential imposition of structural and behavioral remedies. So if the CCI determines that a proposed collection or combination I'm sorry, a proposed combination is anti-competitive, it has the power to prohibit the transaction altogether. So a key feature of Indian merger control is the standstill obligation, which is also known as the suspensory regime, under which parties are prohibited from giving effect to the transaction until they receive clearance from the CCI or until 210 days have elapsed from the date of notifying the Competition Commission of India. So, a failure to notify a notifiable transaction can result in severe penalties, which can be up to 1% of the total assets or turnover, whichever is higher. So, you can imagine, right? 1% of the total assets or turnover, but we're not talking about like lakhs or early crores over here. We're talking about three-figure crores and four-figure crores. So, 1% of that is also huge. So yeah, I mean that make sure that if you're lawyers, and if you're competition lawyers, or if you're assisting with an M&A transaction through and through, which may create the risk of an AEC. I mean, unless it's like a startup or something, you have your CCI route very well sorted. And ideally, if it's a complex transaction, right, which I explained to you in last class, if like a wholly owned subsidiary of one company is acquiring the wholly owned subsidiary of another company, then obviously this is a complex transaction and you might need CCI approval.
So like a triangular merger that you said that it's very complex.
Exactly. That's another example. Um, let's then come to FEMA and FDI policy. I think competition was fairly simple, so I don't think there'll be any doubts. Okay, Yash.
So, the recent amendments that just came around 23, 24 in the CCI
Yes,
Act, so were they
yes,
helpful? As far as I read, they had just increased the threshold for the notification, like more notification, like more threshold has been added so that they have to inform the CCI.
exactly. So what was happening is that a lot of these mergers were happening, and a lot of those thresholds were overseen. We can actually have this discussion in detail sometime, but just for the sake of answering your query, I would say that yes, these thresholds brought about a more nuanced approach to the, I mean, competition act of 2002, because earlier the thresholds were very, very restrictive to fiscal aspects, like, monetary, whatever, in terms of profit or turnover, etc. And at the same time they were looking more at it from the perspective of your acquiring company. But over here, and then of course partly from, they were also looking at the fiscal ability and the market position of the entity being acquired or merged with as well. But what ultimately this amendment brought about is, if there is any resultant operation that is going to be created, what can be the prospective market position of that? And in furtherance of the same, if they have any operations that are linked or that can possibly be linked in either the upstream markets or downstream markets, can there be some sort of monopoly that can be created there, or can there be some sort of adverse appreciable adverse effect on competition that can be created there? So, and apart from that, also they what they also see is, if I mean, if there are operations, I mean, if there are resources that are going to be significantly that are going to be significantly creating an advantage for the Indian entity that is being merged with or that is being acquired, and which can put them in a dominant position, because probably that's what they missed towards going towards a monopolistic towards creating a monopolistic regime, or becoming the sole dominant market player, and possibly, I mean, possibly being a dominant player, them further like abusing their position, and creating an appreciable adverse effect on competition. Then how can that be done? So what the amendment ultimately did is motivated deeper in a more, how do I put this, so lack of better words, penetrative approach towards understanding what the market position or what the market scenario could exactly look like, or what it could be done, or what I mean, how exactly is there going to be an advantage or a disadvantage that will ultimately be brought about? So, and then I'll like, if you look at the few minor aspects as well. I mean, like, after you've looked at how the market can prospectively be impacted, which is what I was trying to say. So this basically introduced a deal value threshold of rupees 2,000 crore. So which means that, I mean, what I'm trying to say is, by what I mean, by which I mean that any combination that is valued for more than, 2,000 crore will just directly come under the scrutiny of the CCI. So currently, to determine whether a combination requires the approval of the CCI, or the values of the value of assets and turnover of the company, which were being considered under the Section 5 of the Competition Act of 2002. But ultimately, this deal value threshold in itself was not really effectively brought about, because what they were looking at is, as I mentioned, just independent party positions. But deal value in itself is also like a very significant assessing factor of the potential of the acquiring entities, the entity being acquired and the acquiring entity, as well as, or the merging entities. So that's another way to look at it and directly scrutinize without really caring to delve into finer aspects, like, before initiating the scrutiny itself. Because even if the CCI is taking suo moto cognizance tomorrow, they will have to come and justify why they took that suo moto cognizance. So now, if they have an amendment in place which is substantially backed by the fact that 2,000 crore really is one which can highlight a dominant position of an acquiring entity and an entity being acquired, or two merging entities in the relevant markets that they operate, then of course, I mean, there is a potential to create an appreciable adverse effect on competition. So the CCI can now directly scrutinize. Um, Apart from that, you also would have, Yash, I'm sorry if you, I don't know if you might be aware of, if you might be aware of this or not. There was an Ultratech cement case or a Jayaprakash Associates Limited case, wherein the CCI has held that control meant the ability to have material influence over another enterprise. But over here, the CCI held that the term control includes material influence and the presence of factors which gave an enterprise the ability, the ability to influence the affairs and management of the enterprise. So those factors could be like special rights, shareholding, board representation, etc. So the definition of control, which basically came under the new amendment, seemed to be on the lines of the above judgment. So I mean, if there is again a control that can therein for like there can therein have to be created, which can ultimately influence market operation of the entity being acquired, and of course which will also be coupled with the fact that certain extent of resources can be provided to them, which can allow for their technical growth and which can allow for their significant influence in India, and of course I mean a more effective technical, I mean, I wouldn't say employment workforce, but more skilled labor, if I could put it that way, uh, is provided, then of course that is all that potential that is being created. So all of these are definitely going to be used as indicative factors by the CCI to look at things. Apart from the deal value threshold, of course, the 210 days I had mentioned while briefing you on whether these people can go ahead with without the CCI's consent or not, is actually an increased number from what was earlier 150 days. So I mean, they just give the because of the amendment bringing about a lot of a requirement for a lot of nuanced approach. This is, I mean, the CCI has been given 2 months additionally, or like 60 days additionally, to ensure that the assessment is as effective as possible. So yeah, I'm sorry I explained a little too much. I hope that answers your question though.
Yes, it did. Thank you so much.
No worries. Let's okay, I'm so sorry. Before, like, I mean, I don't think there are any other questions. I mean, if there are any other questions, please feel free to ask. Okay. It's like a dialogue between Yash and me. Come on, we want more people to involve and more people to participate. I think that's how we can make the learning more effective. So FEMA and foreign direct investment policies regulate cross-border M&A. So in cross-border M&A involving Indian companies, the regulatory architecture is heavily influenced by the Foreign Exchange Management Act of 1999 and the Consolidated Foreign Direct Investment Policy issued by the Department of Promotion of Industry and Internal Trade, that is the DPIIT. So these frameworks are administered by the Reserve Bank of India and are aimed at maintaining macroeconomic stability. So, I mean, in addition to this, of course, excuse me, they also manage foreign exchange flows, which ultimately, and they also protect sensitive sectors of the Indian economy from undesirable foreign influence. Uh, Under FEMA, all capital account transactions, including inbound and outbound investments, mergers involving foreign entities, and issuance of shares to non-residents require either general or specific permission from the RBI. Now, as I had mentioned last class, the let me actually put it very simply. I don't want to complicate it for you. Uh, as I was saying, The most, as I had mentioned in last class, the most significant instrument in this context is the Foreign Exchange Management Non-Debt Instrument Rules of 2019, which lay down sector-specific foreign investment caps, entry routes, that is automatic versus government, pricing guidelines, and reporting requirements for equity investments in India. Now, when a foreign acquirer proposes to invest in India, or an Indian company that is, or merge a foreign company into an Indian entity, that is an inbound merger, such a transaction must comply with India's sectoral caps and conditions laid down in the FDI policy. So, of course, there are exempted sectors like defense, media, telecom, insurance, and civil aviation, which are subject to government approval and impose equity caps, ownership restrictions, and security clearances. Uh, but in the light of, I can say, national interest considerations, any investment from entities or citizens of countries sharing land borders with India, I mean, most notably, of course, our favorites, China and Pakistan, and followed by Nepal, Bangladesh, Bhutan, Myanmar, and Afghanistan, now require prior government approval, irrespective of the sector or investment value. And this is, you can note down as per press note 3 of 2020, I believe. Yeah, but yeah, press note 3. So this amendment has significantly reshaped the contours of foreign participation in Indian M&A activity, particularly in technology and digital sectors. So in case of outbound mergers, however, that is an Indian company merging into a foreign company, the RBI permits such transactions only if the resultant foreign entity is incorporated in a jurisdiction notified under Section 25A of the Companies Rules of 2016, which is the Companies Compromises, Arrangements, and Amalgamations Rules of 2016. So, additionally, Indian residents receiving foreign shares as consideration in an outbound merger must adhere to the liberalized remittance scheme, which imposes limits and also the reporting requirements under the same. Uh, just to repeat, it's the liberalized remittance scheme, that is the LRS, which imposes limits as well as reporting requirements for outbound mergers. The RBI must also approve the merger and it may examine whether the transaction is in compliance with India's ODI regulations, that is the Overseas Direct Investment Regulations, anti-money laundering concerns, and overall financial prudence. So, pricing of shares in cross-border M&A transactions is also tightly regulated. Under FEMA, the pricing of shares is issued to, excuse me, Indian LRS, just to add to your answer, Ajay, LRS is applicable only to Indian residents receiving foreign shares as consideration in an outbound merger. But yeah, fundamentally, by concept, you are right. LRS is applicable only to resident individuals. But yeah, I just, yeah, no worries, Aditya. Um, Sorry, where was I? Uh, yeah, I was at pricing of shares in cross-border M&A transactions. So, so under FEMA, the pricing of shares issued to a non-resident must not be lower than the fair market value determined by a category 1 merchant banker or chartered accountant. And this must use internationally accepted valuation methodologies. So this ensures that Indian promoters do not unduly dilute equity at below market prices, which could lead to loss of national assets or revenue leakage. So similarly, in case of share transfers from residents to non-residents or vice versa, the price must be adhered. The price must adhere to prescribed valuation norms to ensure what we call arm's length outcomes. Um, Let me make sure that I don't complicate this for you. So RBI also mandates reporting of foreign investments within stipulated timelines. So you have the form FCGPR, which is for new shares issued to foreign investors, and then you have the FCTRS, uh, which is for secondary transfers, and then you have for form CN, which is for combinations involving cross-border mergers. And this is ideally to maintain transparency and real-time monitoring for capital inflows and outflows. So, failure to comply with these requirements can result in compounding proceedings and monetary penalties under FEMA. So, let me repeat the forms for you as well as their purpose. You can note it down actually. Form FCGPR for new shares issued to foreign investors. Form FCTRS for secondary transfers, and Form CN for combinations involving cross-border mergers. Now, to maintain transparency and real-time monitoring of capital inflows and outflows is why these forms are mandated. So, the last thing that we'll be looking at under FEMA, actually, no, not the last thing. We'll have to look at FDI policy also. But yeah, the tax implications is what I like to mention here. Uh, So this will come particularly under the Income Tax Act of 1961, which basically must be harmonized with the FEMA and FDI rules. So transactions involving share swaps, issue of preference shares or convertible instruments, or asset transfers may trigger capital gains tax or require tax clearance certificates, especially in cross-border contexts. So India has recently tightened its general anti-avoidance rule, that is the GAAR, and indirect transfer provisions to curb tax avoidance in offshore eminent structures. A very notable example for this is the Vodafone Hutchison case, which hence makes it essential for foreign investors to structure deals with a robust tax and litigation and legal due diligence. Any doubts? Does anyone have any doubts? FEMA is very, very complicated. I understand, but I will actually go through it once more because I'm myself. I feel like I will do a disservice to you if I don't go through it in detail before I come to the taxation aspects in detail. So yeah, but yeah, okay. I'll answer it, Ajay. Anybody else? Okay. I think only Ajay has a doubt. So let me quickly answer Ajay's doubt and then make you like go through FDI policy framework again for you all. So basically, in the Vodafone Hutchison case, what you need to note is that India tightened its general anti-avoidance rule. That is the GAR and indirect transfer provisions to curb tax avoidance in offshore M&A structures. So this hence made it essential for foreign investors to structure deals with robust tax and legal due diligence. So don't end up paying tax on two occasions. So you don't want any investors to end up paying tax on two occasions. That's always a that's you want to incentivize investments in your country, Ajay. You don't want to create a situation where people are saying that there's a double taxation possibility. So who's going to pay so many taxes? I don't want to even invest in this country. So to avoid all of that, you ultimately just ensure that you have stricter GAR provisions, or you have a DTA with the other country, or you have indirect transfer provisions for the purpose of curbing this tax avoidances. And in like particularly, of course, only of course in uh, offshore M&A structures. I'm sorry, I correct myself.
Thank you, sir.
No worries, Ajay. I don't think there are any further questions. Let me just make you revise FDI policy framework. So, sorry, someone unmuted.
No?
Yeah, Ajay, you were saying something?
I'm sorry. I'm sorry.
No worries. So, India's FDI policy, which is updated periodically through press notes and consolidated annually by the DPIIT, provides the baseline for whether a foreign entity can participate in a sector specific or in a I'm sorry in a specific sector through M&A, and foreign investments can be made under two routes, which are automatic and government approval. Under the automatic route, no prior approval is needed from the Indian government, and only post investment filings with the RBI are required. Under the government route, the approval must be obtained from the competent ministry or department, depending on the sector. So sectoral caps and conditions form the backbone of the FDI policy. And for instance, 100% FDI is permitted in sectors like e-commerce, construction, and manufacturing under the automatic route, whereas sensitive sectors such as defense allow for only 75% under automatic. Beyond that, under approval. Telecom, where up to 100% with conditions, and print media, where 26% is approved, and only it is approved only through government route. So M&A transactions that result in acquisition or control of substantial ownership in such sectors are scrutinized not only for compliance with caps, but also for adherence to sector-specific conditions like minimum capitalization, lock-in periods, and local sourcing norms. So additionally, Press Note 3 introduced a major change in response to economic scrutiny, or economic scrutiny concerns rather. And this mentioned that any investment, direct or indirect, from an entity beneficial owner based in countries sharing a land border with India, like China, Pakistan, Nepal, Myanmar, Bhutan, or Afghanistan, now require prior government approval regardless of the sector or investment value. So this change applies to both greenfield investments and acquisitions through share purchase or control transfers, making it particularly relevant for M&A. This was on the FDI policies. Now, let me quickly take you through the NDI rules and the mode of payment and reporting of the NDI regulations 2019. So, like, let me first, you can note down the names of these rules and regulations. This is the Foreign Exchange Management Non-Debt Instruments Rules of 2019 and the Foreign Exchange Management Mode of Payment and Reporting of Non-Debt Instruments Regulations of 2019. So they prescribe detailed conditions for FDI through equity instruments. So these will include four things that we've already discussed. First is pricing guidelines, that is, the prices of shares issued to or transferred from or to non residents must not be less than the fair market value as determined by Category 1 merchant banker or chartered accountant using internationally accepted methodologies. This ensures that Indian assets are not undervalued in foreign hands. So the second is instruments allowed. Uh, So foreign investors may invest in equity shares, compulsorily convertible preference shares, or debentures and share warrants. So non-convertible instruments fall under different regulations governing external commercial borrowings. And then comes your share transfer and issue procedures, everyone, students. where M&A involving foreign investment may involve issuance of new shares or transfer of existing ones. So transactions must comply with investment caps, sectoral conditions, and be reported to RBI through appropriate forums, like the forms that were discussed, like the FCGPR for fresh issues, FCTRS for secondary transfers, etc. I'm sorry, and of course the CN for combinations involving cross-border mergers. Uh, you then have, I mean, the fact that all capital account transactions must be routed through authorized dealer banks and are subjected to post facto reporting. Any deviation may be compounded under FEMA and attract penal consequences. Again, now that I've taken you through FEMA again, are there any questions? So, okay, let's then come to tax implications. This is a little complicated, so pay attention. I will try to be as simple as possible in my approach, but again, very, very, very complicated. So, I will try to, again, if you have any doubts, just interrupt me. You don't have to put it on chat or don't like or raise your hand. That is to say, like, don't raise your hand, just interrupt me or don't put it on chat. Just interrupt me and like ask. Okay, let's get started. So, tax implications and structuring considerations on M&A transactions in India. So, the tax landscape of M&A transactions in India is deeply shaped by the interplay of Income Tax Act of 1961, uh, indirect tax laws, and treaty frameworks. So, strategic structuring of M&A deals is critical not just for regulating compliance, but also for tax efficiency, minimizing transaction costs, and ensuring long-term financial viability. So transactions can be structured in a variety of forms, which will include asset transfers, share acquisitions, mergers or amalgamations, demergers, or slump sales, each of which carries distinct consequences, tax consequences, that is to say, I'm sorry, I correct. I'm sorry, correct myself. This will include buyer, seller, and the target entity. So, yeah, uh, just give me a minute. Let me get it together in my head on how to present it to you simply. I'm so sorry for this. Just give me 1 minute. I'll try to present it in the most effective way possible so that you all don't lose out on anything. Otherwise, I'll just be using a bunch of legal jargons and no one's going to understand anything. Just give me 1 minute. Let me collect my uh, thoughts. Okay, let's do this. So the first we look at direct tax implications under the Income Tax Act of 1961. So the first thing that we look at is asset sale and share sale. So in a share purchase, the buyer acquires shares of the target entity and the company continues as a going concern. So in this case, capital gains tax is levied on the seller, that is the shareholder, depending on the period of holding the nature of shares and the nature of shares. So the two aspects that are looked at are period of holding and the nature of shares. So listed shares, which are usually held for more than 12 months, attract a long-term capital gains tax at 10%, while unlisted shares are taxed at 20% with indexation. But in contrast, short-term gains are taxed at slab rates for residents or at 30 or 40% for non-residents, depending on treaty applicability. However, in an asset sale, the target company sells its individual assets to the acquirer, which may trigger business income or capital gains depending on the type of asset. Now, the company pays gain on tax. And the amount distributed to shareholders is also taxed. And this can potentially lead to double taxation. So the buyer gets a step up in asset base, that is a higher depreciation base, which is a key benefit. Do you want me to repeat it or is it clear? Anybody wants me to repeat it?
Yes, sir. Please repeat it once again.
Yeah, sure, Muskan. So, in a share purchase, the buyer acquires shares of the target entity and the company continues as a going concern. So, in this case, capital gains tax is levied on the seller, that is the shareholder, depending on the period of holding and the nature of shares. So, listed shares are held for more than 12 months at, and they attract long term capital gains at 10%, while unlisted shares are taxed at 20% with indexation. So, in contrast, short term gains are taxed at slab rates or at 30 or 40%, respectively for residents and non residents, depending on treaty applicability. Now, in an asset sale, the target company sells its individual assets to the acquirer, which may trigger business income or capital gains depending on the type of asset. So the company pays tax on gains and the amount distributed to the shareholders is also taxed, which hence creates a risk of double taxation. So the buyer gets a step up in asset base, which is a key benefit. Is it clear to everyone now, or does anyone want me to still repeat it? I have all the time in the world, so if you all have any questions, please feel free to ask. This is your session. Muskan, is it clear for you now?
Yes, sir. Thank you so much, sir.
No worries. Okay, let's move on then. Uh, the second aspect that we'll have to look at is a slump sale. So, a slump sale involves the sale of business undertaking for a lump sum consideration without individual valuation of assets and liabilities. So, it is governed by Section 650B of the Income Tax Act, and the capital gains tax are computed based on the net worth of the undertaking, and the tax treatment depends on whether the undertaking was held for more than 36 months, which is described or determined rather as long term, or less. No indexation benefit is allowed in a slump sale, and the buyer does not get a step up in asset base except for goodwill in certain cases. Any questions? Okay, let's go on to the next one then.
Excuse me, sir.
Yeah, yeah, Ajay, go ahead.
Sorry, I didn't understand actually. Could you repeat it?
Yeah, sure. So, a slump sale involves the sale of a business undertaking for a lump sum consideration without individual valuation of assets or liabilities. So, it is governed by Section 50B of the Income Tax Act, and the capital gains are computed basis the net worth of the undertaking, and the tax treatment depends on whether the undertaking was held for more than 36 months or less. So, no indexation benefit is allowed as well.
Sir,
So next one is
sorry to interrupt.
yeah,
But again, that actually the 36 months period of holding, isn't
yeah.
it changed to 24 months? Sir, after this 20 new amendment, 20 after, if the period of holding of an asset is on or after 23rd, 23 7 something, uh, the month is 24 months.
No, Aditya, I think you are mistaken. The legal position is still 36 months. I mean, I'd like to be corrected if I'm
Transfer is
wrong.
done on or after 23/7/2024. It's 24 months. Could you just check it months? Is that
Okay, I will just check
right?
it and clarify it to you at the end of the class. Then I'm sorry if I have given you incorrect information. I will just check it and clarify at the end of the class. But
Sure, sure.
last I remember working on this, like working with this rather, it is 36 months and not 24 months. But I will definitely check it and come back to you all.
Sure, sir. Thank
Thanks, Ajay. Thanks, Ajay, for pointing it out.
you. Yeah.
So the buyer does not get a step up in asset base except for goodwill in certain cases. So then we have the third category, which is amalgamation and demerger. But Ajay, is the concept clear to you?
Yes, sir. I got it.
Right. Thanks. So amalgamations and demergers, when undertaken in accordance with the provisions of Section 21B, Section 219AA, and Section 47, can be tax neutral. That is, no capital gains tax is triggered on transfer of assets and liabilities if conditions are met. These include two things. First, all property and liabilities of the amalgamating company become property and liabilities of the amalgamated I'm sorry, all properties and liabilities of the amalgamating company become the property and liabilities of the amalgamated company. And the second is shareholders of the amalgamating company receive shares in the amalgamated company. So in such transactions, tax neutrality is available for both companies and shareholders. But the structure must be a court or an NCLT approved scheme. Uh, the continuity of shareholding, business purposes, and compliance with other statutory conditions are essential to avoid reclassification of the transaction as taxable. I think this is all that's important for you in, I think, amalgamations or demergers. So it's just that the tax neutrality is a consideration here. Then there comes the fourth category. I'm sorry, before that, any questions?
So could you please repeat the sections you just mentioned? Clear.
Yeah, it is section 21B, 219AA, and 47, which can basically be tax neutral. That is, no capital gains tax is triggered on transfer of assets and liabilities if conditions are met. Please ignore the disturbance in the background. So these will include two things. First will be, again, Yash, do you want me to mention that as well? I'll just mention it nevertheless. In case you're already aware, it will be a good revision for you. So all property and liabilities of the amalgamating company become the property and liabilities of the amalgamated company, and shareholders of the amalgamating company receive shares in the amalgamated company. And in such transactions, tax neutrality is available to both companies and shareholders, but the structure must be a court or NCLT approved scheme. Okay.
All right, got it.
Yeah. So the fourth category is a set off or carry forward of losses. So under section 72A, the amalgamated company can carry forward and set off the accumulated business losses and unabsorbed depreciation of the amalgamating company, provided certain conditions are met. So, most importantly, continuation of the business and holding of at least 75% of the book value of fixed assets for at least 5 years. So, demergers related reliefs are available under Section 72A4 on similar lines, and these provisions act as significant incentives for financially distressed or strategically aligned mergers. And I believe it's a fairly simple concept, but yes, if anyone has any questions or anyone wants me to repeat anything, please let me know. Let me just blur my background. I'm sorry, I don't intend to disturb anyone. Yeah. Is it not blurring? Yeah. Okay. I think that is none. Let's move on to indirect tax considerations. That is GST and stamp duty. So under the goods and services tax regime, the importance, or I'm sorry, let's put that aside for now. Under the goods and services tax regime, the transfer of an ongoing of a going concern, that is a business undertaking, is exempted from GST, provided it qualifies as a going concern under the relevant GST law. So, however, individual asset transfers like machinery, stock are subjected to GST. Now, the buyer may be entitled to input tax credit depending on whether their registration status and nature of assets, I mean, deem them eligible or not. So, in case of share transfers, GST does not apply, and since securities are outside the scope of GST. However, what may be pertinent to note is transaction advisory fees, legal fees, and diligence costs are subject to GST, and companies often structure reimbursement models accordingly. Stamp duty is another significant cost in M&A, and especially for asset transfers in court or NCLT approved mergers. So the rates vary across states. Sorry, is that a question? No. No. And are often higher for immovable property transfers. So, in contrast, shares through depositories are relatively low cost and attract 0.015% stamp duty under the Indian Stamp Act of 1899. I mean, as was amended, of course. So then comes your cross-border transactions and treaty planning, where you have to understand that cross-border M&A deals involve non-residents acquiring Indian shares or businesses, which attract scrutiny both under Indian tax law and double taxation avoidance agreements, that is the DTAs. So the 2012 amendment, notably to Section 9 of the Income Tax Act, clarified that indirect transfers of Indian assets, that is, through transfer shares of foreign companies holding Indian subsidiaries, are taxable in India. And a position, and I think this position was upheld in the Vodafone case, but it was later legislatively overturned in part through the 2021 retrospective tax repeal. That is, these taxes were basically being imposed retrospectively as well, but the 2021 amendment did away with it. So non-residents typically claim relief under the DTAA, that is the double taxation avoidance agreements. Yes, to avoid, excuse me, excuse me, to avoid or reduce capital gains tax subject to limitation of benefits clauses. So since the general anti-avoidance rules, that is GAR, came into effect in 2017, treaty benefits are closely scrutinized to check for impermissible avoidance agreements. So withholding tax also plays a role in structuring cross-border payments. For instance, consideration paid to non-resident seller may attract withholding under Section 195 unless a tax residency certificate and nil deduction certificate, that is the TRC, and of course, the nil deduction certificate is not abbreviated as anything, are obtained. Any doubts in these two for anyone? We're going to go overtime as usual. I'm really sorry, but these are very important concepts that I can't leave half explained. Are there any doubts? Like, these are very, very nuanced and intricate concepts. So if you have any doubts, please ask. So okay, that's good. Then I think everyone's good. Let's come to the fourth one, which is use of intermediate holdings or your intermediate holding companies and trusts. So to optimize tax efficiency, many M&A deals are structured through intermediate holding in tax favorable jurisdictions. However, such structures must demonstrate genuine commercial substance and compliance with BEPS. That is the base erosion and profit sharing, which are standards basically, the BEPS standards, base erosion and profit sharing, profit shifting standards. The POEM, that is the place of effective management rules, as well as the GAR, that is, I mean, like general anti avoidance rules, to avoid tax litigation. So private equity funds often use trust structures to pool investor money and achieve pass-through taxation under specific provisions for alternative investment funds. So the tax treatment at funds and investor levels affects deal viability. I'm sorry, I correct. Any other questions on in this regard before I move on into your key regulatory hurdle? Oh, sorry, before I move on into a case study, we're going to have a wonderful case study that we're going to be looking at to mark the end of this class. Okay, I think everyone's an expert suddenly. Uh, let's get started with our case study. How many of you have heard of the Walmart acquisition of Flipkart? 2018. Nobody? Okay, that's what we're going to be dealing with in today's class as part of our case study. I will take you through each and every aspect of how what exactly came relevant as regulatory hurdles and how they were ultimately overcome. So in 2018, Walmart Inc., which is a US based retail giant, as many of you would be aware, acquired a 77% stake in India's, now formerly India's leading e-commerce platform, uh, Flipkart, for approximately US $16 billion, which marked one of India's largest cross-border M&A deals. So it was hailed for a landmark transaction, but it also brought to the forefront the complex regulatory landscape surrounding foreign investment in India, particularly the digital commerce space. Now, if you may recall, up to 100% of your foreign investment is allowed in e-commerce. So yeah, Walmart took advantage of this, and Flipkart was already facing competition because of Amazon and all of these other smaller specific service-based retail platforms, or sorry, e-commerce platforms that came into place. So under, like, let's look at the key regulatory hurdles and challenges first. The first is the FDI policy restrictions in e-commerce. So under India's FDI policy, 100% FDI is permitted under the automatic route in the marketplace model of e-commerce, which merely acts as a platform between buyers and sellers, but not in the inventory-based model, where the e-commerce company owns the inventory itself. Now, Flipkart at the time of acquisition operated a hybrid model, and concerns were raised about whether its model violated the FDI norms by indirectly influencing prices or controlling inventory through preferred sales. So the DPIIT at that time had earlier issued Press Note 3. This is the 2016 series, and later Press Note 2 in the 2018 series, which tightened restrictions and increased regulatory scrutiny. And Walmart had to give extensive undertakings and modify internal structures to ensure compliance. So then comes the CCI approval. So the Walmart Flipkart deal obviously required mandatory approval from the Competition Commission of India under Competition Act of 2002, because it crossed the asset and turnover thresholds that were prescribed under the combination regulations then. So, although the CCI cleared the deal, it received formal objections from trader associations like the Confederation of All India Traders, which alleged that the acquisition would lead to market dominance and predatory pricing. Now, despite granting the approval, the CCI emphasized that it reserved the right to investigate any abuse of dominance or anti-competitive conduct. Uh, and I think, I mean, I'm like this, of course, comes under sections 3 and 4 of the Competition Act of 2002. So this caution signaled a behavioral oversight regime, even if, of course, the structural approval was granted. The third is the FEMA and RBI compliance. So cross-border deals are, as we have discussed, subject to the FEMA Act of 1999 and associated regulations administered by the Reserve Bank of India. So Walmart had to ensure that the inflow of funds complied with pricing guidelines, reporting requirements, and valuation norms for share transfers involving non-residents. Additionally, the transaction required structuring through intermediate holding entities, and concerns around round tipping, which is basically prohibited under Indian FEMA laws, had to be addressed to prevent regulatory backlash. You then have the fourth hurdle that came into place, which are the tax and indirect transfer considerations. So, though Flipkart was an Indian entity, part of its holding structure involved companies based in Singapore and other jurisdictions. So, given the experience in the Vodafone tax litigation, uh, where the Indian tax department sought to tax an indirect transfer of an Indian asset via an offshore transaction, Walmart undertook a comprehensive due diligence to ensure no capital gains tax or withholding tax liabilities arose. So while Walmart directly acquired shares of Flipkart's Singapore-based entity, Flipkart's Singapore-based holding entity, Indian tax authorities were scrutinized to ensure no indirect transfer of Indian assets occurred in a taxable manner, and the detailed representations and indemnity clauses were built into the share purchase agreements to address retrospective and contingent tax liabilities. The last risk that we shall be covering now is the data protection and consumer protection risks. So, as part of the post acquisition scrutiny, questions arose about handling consumer data by a foreign entity. We obviously did not have a robust Information Technology Act back then, but now with the DPDPA rules coming into place, and of course the DPDP Act coming into place, which was under discussion even back at then. Because yes, you remember we had multiple versions of the bill: 2019, 2020, 2021, 2022. It never stopped. So it was already under discussion then. And apprehension existed about cross-border data transfers and localization requirements. Excuse me. So Walmart had to exchange with regulators to clarify its data processing policies to ensure ring fencing of Indian data and prepare for compliance with emerging privacy norms, thus adding a regulatory compliance overlay to the transaction's operational strategy. Any questions on this so far? Before I move on into quickly telling you what the implications were. A little weird keeping my laptop like that. Why the screen's up and only my neck is when my face is being shown. Any questions? Any questions at all? Just ask. It is not an easy merger. I'm sorry, it is not an easy acquisition to get your head through. That's why I just ask. Now, if I ask you any of you questions on this, will you all be able to answer? Okay. I take that as none. I mean, I can't force it out. But please, if there are any questions, ask. I think I'll just take a minute more. So the last part of the class is implications and lessons from this. So this transaction basically, I mean, exemplified the multi-layered regulatory scrutiny that crossed that cross-border M&A deals face in India, particularly when they involve strategic sectors like e-commerce, technology, and retail. So key takeaways include cross-border deals, like you have to having consider not just sectoral FDI caps but also restrictions on operational structures and influence. So CCI clearance also is important, like because even when granted, it can come with ongoing behavioral expectations and does not preclude a future antitrust scrutiny. Then on the third level, we have complex holding structures involving offshore entities are not immune from indirect transfer or tax implications of FEMA concerns. Then your new age concerns like data sovereignty, cybersecurity, and consumer protection are increasingly material to deal clearance. And lastly, of course, your meticulous due diligence is needed alongside proactive engagement with regulators and detailed deal documentation with tax indemnities and compliance covenants are essential to navigate cross-border regulatory hurdles. Any questions on this? Okay. Uh, I think that's over to you then, Preksha. Thank you everyone for attending.
Thank you so much, sir. It was lovely learning about all of this. Um, the rest of you, the people who are attending, I will be sharing a attendance form which you will have to fill out. Please do that before you actually leave. Uh,
Yes, yes. You have a doubt, I think.
So I don't have a doubt really, but the thing is that these things are quite new for me. Just I'll just be speaking for myself. These are quite new for me. That's why I don't comprehend it really well. But I did some of it. But what I'll do is I'll just go through a recording and reach out to you after the session. And so can we also do one thing that in the next session while you're explaining, can you just share a like Word doc or a PPT? So that would be a really
Yeah, I don't
comprehensive.
mind. Surely, I'll do that. I don't mind sharing a PPT, but I mean, see, ultimately in a PPT, I will just capture key terms, right? Like I can't put everything I speak on a PPT.
Exactly.
So that's why if you want, I can put a PPT up, and then if that'll help, let that help. Not a problem at
So
all.
if it's possible for you.
Yeah,